Hello, welcome to the next episode of the Advocates Lounge. My name is Michael Cahilll, and today I'm going to be talking to you about sexual risk orders and hopefully giving you a guide as to how to deal with these if you come across one in practice. So, what are sexual risk orders? I'm sure most people watching this talk will be more than familiar with sexual harm prevention orders, commonly known as SHOPOs, which are usually an inevitable consequence of a conviction for a qualifying sexual offence. Sitting alongside the suite of behavioural orders available to manage individuals who are considered to pose a risk of sexual harm to others are sexual risk orders. So, sexual risk orders, or SROs, are civil orders that were introduced in 2014 as a replacement to the risk of sexual harm orders, as SHOPOs were a replacement for sexual offences prevention orders. These allow individuals to be subject to a wide-ranging set of restrictions without any need for a criminal conviction. That principle acts in the same fashion to that of a non-molestation order that can be imposed by the family court on the basis of findings established at the civil standard, or the use of a restraining order made on acquittal where a criminal court can be satisfied of conduct on a civil standard justifying an order. This is the distinction between the sexual risk order and the sexual harm prevention order, which obviously requires the subject to have been convicted of a relevant qualifying offence. An application for a sexual risk order can only be made by or on behalf of a chief officer of police, so a chief constable or the commissioner of the metropolis, or the Director General of the National Crime Agency. In practice, you're most likely to see these coming from chief constables of police. Sexual risk orders are civil orders heard on complaint in the Magistrates' Court at the first instance, in the same way as almost all proceedings that are commenced in the Magistrates' Court. A route of appeal lies to the Crown Court in the usual way, and obviously the right to state a case exists in the same way as any other matter heard on complaint in the Magistrates' Court. So then, what must the police prove to invite the court to make a sexual risk order? In all matters such as this, it must be remembered that the jurisdiction to make a sexual risk order comes from statute. And so, as with any creature of statute, it is essential that the terms of the statute are robustly examined. Sexual risk orders are created by Section 122A of the Sexual Offences Act of 2003. This states, in subsection 1, a person mentioned in subsection 1A, the applicant, may by complaint to a magistrate's court apply for an order under this section, a sexual risk order, in respect of a person, the defendant, if it appears to the applicant that the condition in subsection 2 is met. The condition is that the defendant has, whether before or after the commencement of this part, done an act of sexual nature as a result of which there is reasonable cause to believe that it is necessary for a sexual risk order to be made. We then go to subsection 6. On an application under subsection 1, the court may make a sexual risk order if A, the court is satisfied on the balance of probabilities that the defendant has, whether before or after the commencement of this part, so it doesn't matter when it's happened, done one or more acts of a sexual nature alleged by the person making the application. And B, the court is satisfied that as a result of the defendant acting in such a way, it is necessary, note that word there, necessary, to make such an order for the purpose of either 1, protecting the public or any particular members of the public from harm from the defendant, or 2, protecting children or vulnerable adults generally, or any particular children or vulnerable adults from harm from the defendant outside the United Kingdom. So, looking at first principles, these are civil orders. The burden of proof still rests on the police as they are the ones bringing the application. The standard of proof is the balance of probabilities. In other words, what is more likely than not. Therefore, the burden of proving on the Chief Constable is this: 1, that the applicant has done an act of a sexual nature, and 2, as a result of that act, it is necessary for there to be an order. So in other words, there needs to be an order in order to regulate his behaviour as a result of that risk. That is, in other words, to protect vulnerable members of the public from harm within this country or overseas. That is ultimately the test. So, the first part of the test, an act of a sexual nature. At first blush, this may seem straightforward. However, what is and what is not a sexual act is not defined by the legislation. And so care must be taken to ensure that the police are alleging acts of a sexual nature. I've dealt with cases on appeal where magistrates' courts have made sexual risk orders on the basis of extreme violence against individuals in a domestic context. Upon scrutiny of the allegation, it's been possible to distinguish the sexual conduct from the matters complained of. For example, I dealt with one case where police alleged that an argument that ensued following consensual sexual intercourse, which resulted in a defendant inflicting serious injuries upon a victim, was an overarching sexual act. Upon proper analysis, it could be seen that the sexual act was merely incidental to the incident, a mere background. It was not part and parcel of the misconduct, and so therefore the sexual act had no relevance to a sexual risk order. Contrast that to a situation where an individual repeatedly invites those under the age of 16 to his property, despite repeated warnings. Notwithstanding the fact that at that stage no allegation of sexual impropriety is being made by the young person, it would be within the jurisdiction of the court to consider the context and whether or not the behaviour could be considered to amount to grooming behaviour. A classic example of where something that is on its face non-sexual can be treated as sexual is someone stealing shoes in furtherance of sexual gratification. The guidance here must be this: each case turns on its own facts. Context is key, and it is important that whether or not the act complained of can properly be categorised as sexual is rigorously examined, as without this, the jurisdiction to make an order does not arise. A really important thing to consider in this context is hearsay, as you'll most likely find that the applicant in these sorts of cases relies on a great deal of hearsay in order to seek to prove a sexual act complained of. In common with civil proceedings generally, the rules in respect of the exclusion of hearsay evidence are disapplied. It obviously goes without saying that there's no need for the police to make any bad character applications either. Hearsay is admissible in civil proceedings pursuant to Section 1 of the Civil Evidence Act of 1995. However, those seeking to adduce hearsay evidence should file a hearsay notice under Section 2, which sets out A, notice of the fact that they intend to adduce the statement as hearsay, and B, on request from the other party, I do recommend that you do this, such particulars of and relating to the evidence as is reasonable and practicable in the circumstances for the purposes of enabling a party to deal with any matter arising from the matter being hearsay. It is important to remember that a failure to serve a notice does not lead to a hearsay statement being inadmissible. However, it may be taken into account by the court pursuant to Section 1, subsection 4 of the 1995 Act in the following ways. A, in considering the exercise of its powers with respect to the course of proceedings and costs, and B, more importantly for the purposes of this talk, as a matter adversely affecting the weight to be given to the evidence in accordance with Section 4 of the 1995 Act, which we'll come on to shortly. Section 3 of the Act provides for the ability to give a notice of a wish to cross-examine. If a defendant wishes to object to the calling of any of the served witnesses as hearsay, the defendant may issue a notice under Section 3 of the 1995 Act of an intention to apply to cross-examine the witness in question. The notice should be issued within 14 days of the hearsay notice. A tactical decision must be made at this stage as to whether it would be beneficial to seek to cross-examine the witness or challenge the quality of the evidence under the hearsay provisions. Well, how do we do that? Let's look to Section 4. These are the statutory factors determining the weight to be given to hearsay. The police have submitted their hearsay evidence. How does the court receive it? And how is it best challenged or supported, as the case may be? The court is directed under Section 4 of the Act to have regard to the following factors in determining the weight to be given to hearsay evidence. Subsection 1, in estimating the weight, if any, that's important because the court doesn't have to give any weight to the hearsay evidence. So in estimating the weight, if any, to be given to hearsay evidence in civil proceedings, the court shall have regard to any circumstances from which any inference can reasonably be drawn as to the reliability or otherwise of the evidence. Subsection 2, regard may be had in particular to the following. A, whether it would have been reasonable and practicable for the party by whom the evidence was adduced to have produced the maker of the original statement as a witness. B, whether the original statement was made contemporaneously with the occurrence or existence of the matters stated. C, whether the evidence involves multiple hearsay. D, whether any person involved had any motive to conceal or misrepresent matters. E, whether the original statement was an edited account or was made in collaboration with another or for a particular purpose. And F, whether the circumstances in which the evidence is adduced as hearsay are such as to suggest an attempt to prevent proper evaluation of its weight. So, we have our hearsay. How do we challenge it? I'm going to go through some key factors in challenging hearsay evidence. The following should be borne in mind in challenging hearsay evidence. Firstly, the fact of an arrest or an interview is irrelevant as to the question of whether an allegation is substantiated. It does not support whether a defendant has been involved with an incident one way or another without the underlying evidence being provided as to how the defendant in question came to be arrested, so that the evidence can be tested and the court can weigh the information and come to a value judgment. The fact of a previous allegation does not satisfy the burden of proof. The allegation must be tested. The admissibility of hearsay evidence in civil proceedings does not mean that such evidence is accepted at face value. This issue has been considered by the President of the Family Division in the context of a local authority seeking to use logs and records to prove facts, just in the way the police often seek to do in applications for sexual risk orders. Where James Mumby, the President of the Family Division, stated in Re a Child 2015 England and Wales Family Court 11, I draw attention to what in Re a Child number 2, 2011 England and Wales Court of Appeal Civ 12, paragraph 26, I described as the elementary proposition that findings of fact must be based on evidence, including inferences that can properly be drawn from the evidence and not on suspicion or speculation. This carries with it two important practical and procedural consequences. The first is that the local authority, if its case is challenged on some factual point, must adduce proper evidence to establish what it seeks to prove. Much material to be found in local authority case records or social work chronologies is hearsay, often second or third-hand hearsay. Hearsay evidence is, of course, admissible in family proceedings, but, and as the present case so vividly demonstrates, a local authority which is unwilling or unable to produce the witnesses who can speak of such matters firsthand may find itself in great or indeed insuperable difficulties if a parent not merely puts the matter in issue but goes into the witness box to deny it. As I remarked in my second view from the President Chambers 2013 Family Law 680, of course the court can act on the basis of evidence that is hearsay, but direct evidence from those who can speak to what they have themselves seen and heard is more compelling and less open to cross-examination. Too often, far too much time is taken up by cross-examination directed to little more than demonstrating that no one giving evidence in court is able to speak of their own knowledge, and that all are dependent on the assumed accuracy of what is recorded, sometimes at third or fourth hand, in the local authority's files. The further removed the hearsay evidence is from the original evidence, the less weight that can be applied to it. It can often be seen that the police will seek to rely upon logs or records that contain second or third hand material as opposed to original statements or transcripts of interviews. Multiple hearsay is inherently less reliable and more subject to challenge than first hand hearsay. In the absence of a witness statement explaining why the original makers of the statement are not available, the police are inherently vulnerable to a submission that they have failed to demonstrate why the original makers of statements cannot be called to give evidence, and that weight should be construed against them under Section 42A of the 1995 Act. The key takeaway is that hearsay evidence is admissible. However, admissibility does not equate to weight. Just because evidence is admitted does not mean that it will be accepted, and therefore applications based upon hearsay alone are more vulnerable than those that can call direct evidence. So that's dealing with the police's evidence. What about the defendant's evidence? Remember, as civil proceedings, it's essential that the defendant puts forward any matters upon which they wish to rely in a formal witness statement with a statement of truth attached. This is equally the case for any other witnesses that the defendant wishes to call. The statement will be treated as evidence in chief, so it is essential that it covers all matters that the defendant wishes to raise in the defence of the application, as supplemental examination in chief will be at the discretion of the court. It goes without saying, however, that anything which this defendant would put forward in the sexual risk order proceedings can be used against them in any future proceedings. Therefore, care must be taken to make sure that the defendant does not open himself up to any sort of self-incrimination or provide any evidence against him in terms of possible future proceedings. We can now look at the second part of the test, the necessity of an order. Whilst it's always for the police to demonstrate that an order is necessary to protect the public from a defendant's sexual harm, it's important to consider whether any evidence may exist to assist the defendant in this regard on his own defence. Perhaps there could be a probation report dealing with general recidivism that may be of assistance if the defendant's been before the court recently and was assessed as being of a low risk in another context. Consideration could be given as to the instruction of a psychological or psychiatric report in respect of the defendant's sexual risk. As always, if the report is unhelpful, there's no requirement that it's relied upon. It must be remembered that the police must reach the level of necessity. In other words, the order must be required. That necessity must follow from the facts that the court has found. It does not follow, therefore, that just because some sexual misconduct has been found, that an order will follow. In a recent case I dealt with, the police were left with only a finding that 15 years previously, a defendant had inappropriately touched someone at work. Given the time that had elapsed without any other allegations established, the court determined that it could not be said that an order was necessary, and the application was dismissed. Now, let's assume that a court has decided it's going to make an order. What about the terms? Well, in common with sexual harm prevention orders, the order must be proportionate to the risks identified and drafted in such a way that the terms are sufficiently clear and easy to understand. Whichever side one appears for in these applications, the questions that must be asked are these. Can this order be properly enforced? Is it clear what conduct would amount to a breach or of any prohibition? If there is any doubt, the order should be redrawn to ensure that clarity. So some final remarks and takeaways. Remember, sexual risk orders are a significant impingement on an individual's liberty in circumstances where they have not been convicted of any offence. It's important that any application is scrutinised and the tactics for challenge are considered at an early stage. Not only that, but it's important to remember that a breach of an order is a criminal offence, which carries with it a maximum sentence of 5 years imprisonment. Not only that, but anyone who an order is made against must provide the Chief Constable of the police area for which they reside their name and address within 3 days of the order being imposed or 3 days of that information changing. I hope that you found this talk interesting and informative. This has been the latest edition of the Advocates Lounge. Keep out and check out our website for future editions coming shortly. Thank you very much. Good day.